All right, thank you, Alex. That was an excellent presentation, and I'll sort of follow on with my remarks. If the current coronavirus epidemic has signaled the emergence of online hearings, I wonder if following the crisis, we're really seeing the end of in-person hearings. And so I just wanted to take a moment to pause and look before we leap through the looking glass. Um, I noticed in reviewing the rules in the rulebook that only a few of the major arbitral regimes provide for the use of video conference in certain situations, and there are four. One is for procedural conferences. The second is for expedited proceedings. The third is for emergency arbitration. And the fourth, under the IBA rules of evidence, is to use in exceptional circumstances for the testimony of a, quote, particular witness. But none of the major arbitral regimes imagine putting the entire hearing online, with the exception of LCIA rules 19.2, suggesting that you could possibly hold the hearing online or do some kind of combination of in-person and virtual hearing. We do have the sole protocol on video conferencing, but as has been noted by publication by Linklaters, that is really geared towards interviewing a particular witness consistent with the IBA rules, but perhaps not for guiding parties and counsel and arbitrators on conducting the entire hearing online. And so I thought it might be useful to recall what is the significance of in-person hearings and why have we been doing it that way for centuries. And in my research, really the focus seems to be on assessing truth or falsehood of the testimony of fact witnesses. And this is perhaps for two reasons. One court that I came across considered that if a witness is going to not tell the truth, they might find it easier to do so or be more inclined to do so from the comfort of their office talking to a video screen, as opposed to entering a hearing room facing the arbitrators, counsel, their peers, and former business partners. And so that might be a factor where in-person hearing is important. And the other one is assessing that witness credibility through the video conference. Right now, if I'm very nervous, I could be twiddling my thumbs, but you can't see that because they're off the screen, or I could be bouncing my knee up and down nervously. Those types of body language and nonverbal cues are lost. So there are a number of sources that make this particular observation and express this concern. And so perhaps cases that really turn on the credibility of a key witness testimony might not be appropriate to go online, or at least that portion of the case. There are, of course, other issues, even in such cases, that could be adequately addressed through video conference. And just thinking of, for example, in closing argument,
Ryan, we've lost your sound.
Okay.
We can hear you now.
You're good now. You're good now.
Okay, I was able to hit the recycle button here, so that's good. So I was just saying that perhaps portions of hearings could be done online, especially through a hybrid approach, but that perhaps in certain cases, key witness testimony where credibility is critical might need to be in person. Turning back to the rulebook, the issue of whether most or all of the hearing can be conducted online is really something that the arbitral regimes will want to address. And until then, parties may want to address this issue in their arbitration agreement. And in Chapter 2 of the rulebook, we address a number of essential elements of arbitration agreements, highly recommended provisions, and other options. And within that framework, parties may want to add to the list discussion about whether to include something in the arbitration agreement about whether the hearing may be held online. And then I think that certain soft law guidelines would be useful in actually carrying out the conduct of an online hearing based on best practices. And until we have sort of official guidelines of that nature, as Alex mentioned, the time for parties to sketch out the procedures for online hearing is at the procedural conference. And that is addressed in Chapter 5 of the rulebook. With a nod to this, ICDR rules Article 20.2 contemplate that at the preparatory conference, the tribunal and the parties may consider how technology may be used to increase the efficiency and economy of the proceedings. So that would be the moment to address that. And so I think I'll just close because I know we're running out of time. Certainly, the coronavirus epidemic has pushed all of us out of our comfort zones in many ways, including in our practice of international arbitration. When those moments happen in our lives, that's when we grow and innovate. And I think that coming out of the epidemic, we will see increased use of online hearings in a variety of cases. And when we do so, I hope that we'll recall what might be lost in certain scenarios by foregoing the in-person hearing, and that's a discussion to have with clients for sure. So with that, I'll conclude my remarks, and I think I'll turn it back over to Chian.